All right, to this big story now as well today, as oral arguments begin just moments ago in the Supreme Court. The justices are hearing the landmark case from Hobby Lobby. This is a huge day. This case really gets to the heart of the ObamaCare mandate that businesses provide contraception coverage for their employees as part of any plan that can be approvable. Judge Andrew Napolitano is a Fox News senior judicial analyst. Of course, you know him well. Judge, good morning. Good to see you. What's at the heart of this case, in your opinion?
Religious liberty, and whether or not the Supreme Court, whether or not the Congress can compel corporations to violate the religious liberty of the shareholders of those corporations. There's a lot of subsidiary issues. Do corporations have religious liberties, or do just individuals? Right. Can the owners of the corporation impose their own religious standards on the corporation itself? And the big picture, can Congress do this to anybody? Make you buy a product, contraceptive health care coverage, that goes against the very teaching of your religion from your heart.
All right, let's listen to this soundbite that was played earlier in Shannon Bream's piece from one of the attorneys for the Beckett Fund, who is arguing on behalf of Hobby Lobby.
This is unquestionably a religious exercise, refusing to pay for something that could take a human life. And so the question here is not whether it's the Green family or the corporation, both of whom are part of this case. The question is this a sincere religious exercise? And the answer to that is yes. So it ought to be protected.
All right, so...
You know, it's interesting she said could take a human life. Most people need to realize this is not just contraceptive, traditional contraceptive coverage. This is also coverage for euthanasia and abortion. It comes in one package in the federal government's mind that orders the people, the entities that employ 50 or more people, to make this available to their employees. Now, this is not to say that women are not entitled under the law to choose on their own to have this protection. It's the flip side. It's our employers free to choose not to pay for this protection because they find it morally and religiously repugnant.
And we've seen this extended to religious organizations. The government has said, you know, that the church, for example, doesn't have to cover these plans that include contraception. But then the next leap is whether or not a private company, a private corporation, can also say it's against our religious beliefs as well. But some people, you know, the other side is arguing an employee who exists and works in the United States of America under this law that says that everybody must be covered by a plan that is, you know, up to their definition of what's good enough for them, should say, well, if this is where I want to work, why shouldn't I be covered by the same description of these plans that everyone else who works in other places is covered under?
Well, I'll give that employee an answer, because your wish to be covered by contraceptive coverage paid for by your employer is a good that the employer purchases for you. But the employer's wish to serve his or her heart and to follow his or her religious beliefs is a right that comes from our humanity and is expressly guaranteed
so you got to work somewhere
by
else.
the First Amendment. Yes, or go out and pay for it yourself, or get the federal government, which subsidizes billions in these policies, to pay for it, which is probably what will happen if the Supreme Court rules against the federal government. The federal government will offer to subsidize it, which basically means
is what they did with the Christian organizations as well.
Right.
Exactly.
Which means all of us.
Right.
You and I and our religious beliefs and our tax dollars will be subsidizing
these policies. They took it off the table of religious organizations and put it back on the insurance company's table and said, you pay for it. They're not going to actually funnel that money towards contraception, which some people say is a bit of a misnomer.
This is an unintended, I shouldn't say unintended, an unforeseen consequence of the Supreme Court's ill-advised decision a year and a half ago, finding all of this constitutional on the grounds that if you don't do it, we can tax you, and the government can tax anything it wants.
Wait, it's going to be really interesting to see how the Chief Justice comes down on this, because you and I were talking about this. I mean, literally, his decision that this entire health care plan was would levy a tax on you if you did not subscribe to it, rather than a fine, is what allowed this whole plan to go forward. And we literally have not heard hide nor hair of the Chief Justice since then.
It really is a bizarre decision in this respect. The government argued it wasn't a tax, and the challengers argued it wasn't a tax. And yet the Supreme Court rejected all the arguments before it and found that as a tax.
And said, we don't care what you call it, government, we call it a tax.
It's obvious this was just a cobbled together compromise by people who otherwise disagree with each other on fundamental jurisprudential views in order to salvage this legislation. And as a result, we have these challenges coming back. And another challenge on its way to the Supreme Court that they're going to hear a year from now: can the government subsidize certain policies
and
irrespective of the wealth?
That's in our to be continued category. You and I will take that up in the elevator or the hallway, and then back here at a later date. Thank you, Judge.
Hammer's got an opinion on that one.
Of course he does. Thank you very much, Judge. We'll see you next time. Bill?